A federal appeals court heard our case involving the fire chief who was fired. One of our attorneys will help us understand what happened. I'm Stuart Shepard, and this is First Liberty Live. Have you downloaded our app yet? It's an easy way to keep track of these conversations. You can watch it on the app, or you can just listen while you're driving or doing other things. It's free download. Just look for it, the First Liberty Live app. David Hacker is our Vice President of Litigation and Senior Counsel here at First Liberty. Hi, David.
Hi, Stuart.
Thanks for making time for us. This episode is a companion piece to what happened on Monday when our case involving Fire Chief Ron Hittle, who's over my shoulder here, was heard at the Ninth U.S. Circuit Court of Appeals. If you want to hear that argument, we did a little preview, Jeff Mateer and I did, of what was about to happen, and then picked up the argument as it was happening. You can watch that on firstlibertylive.com if you want to get the detail there. So this is to help you along. If you watch that and you wonder, okay, what did I see? What happened in the course of that? So David, first, what was your impression of how it went? Were you happy with it?
Yeah, I thought the argument went very well for our side. The judges asked, pointed questions about what happened to Chief Hittle, and our advocate, Elizabeth Butler, did a great job of answering all those questions, I thought.
Let's talk about her a bit. Where's she from? What's her background?
So Elizabeth is an attorney with the law firm of Baker Botts, and she and her co-counsel, Aaron Street, were our volunteer attorneys on this case, and they just did an exceptional job, I think, with the briefs that they had to file at the court and then today's argument.
If you watched it on Monday, you didn't see Aaron, but he's right outside of camera view, right? Describe the room for us, what it was like as this was being, because it was held online. I mean, it's like a Zoom meeting kind of court session. Describe what the room was like where this was happening.
Yeah, normally, we'd all be in the courtroom, and, we'd be sitting at counsel table, and the judges would be up at a podium above us. But here, what we did is we actually just did it in our studio here at First Liberty. We set it up so Elizabeth was, the star on Zoom, and Aaron's sitting to her side, with the notes and record and notebooks that we need for the argument. And I was sitting also off camera and just making sure everything went well for the argument. Really there to support Elizabeth and make sure she succeeds.
Part of the power of First Liberty Institute is that joining of the volunteer attorney, and Baker Botts is a world-class law firm, with our attorneys here who are specialists when it comes to religious freedom cases. Describe that relationship to help people understand how that works.
Yeah, it's a phenomenal relationship, and we're so blessed to have many volunteer attorneys at some of the biggest law firms in the world that work on our cases. And many people come to First Liberty needing legal help with religious discrimination, and we're able to pick cases that we think will have success and that we can win, and then we go and we partner with these large law firms who have many attorneys that are just really excited to do a religious liberty case. And so it's a huge blessing. These are attorneys that are being hired by some of the biggest companies in the world on a normal day-to-day basis, and then they step in and they do a religious liberty case, like for Chief Hittle. It's a win-win for everyone.
And they do it pro bono. It's for free.
That's right. That's right. Yeah.
And it's just awesome that we get their expertise with that and then match it with First Liberty. It's just phenomenal. What did she have to accomplish in the courtroom? What was the goal going in? What were you trying to do?
For an oral argument like that at the appellate stage, you've already written these long documents that we call briefs. They're actually not very brief. They're many pages long, outlining our legal argument. And the judges have already read all that by the time they get to oral argument. So really, your purpose when you step up to the lectern there is to be available to answer the judge's questions. Beyond that, if you can make your most important points, maybe your 2 to 3 most important points as to why you should win, that's your other goal. But really, you're there to be a help to the court and to answer their questions, see what they're struggling with. Maybe it's something about the facts, maybe it's something about the law, and you're there to help them work through that.
And if you haven't watched many of these, sometimes it will appear like one of the judges is really going after an attorney, but they're just trying to fine-tune a point to understand what's in and what's out, right?
That's right. That's right. And I think today, or on Monday, you saw that one of the judges in particular had a lot of questions and was really diving into what happened to Chief Hittle when he got fired by the city of Stockton, and wanted to know a lot of particulars about the decision to fire him and what it was based on. And so a lot of Elizabeth's job, at least at that point, was to answer his questions, point him to the record and where things were recorded in the record in terms of depositions and, affidavits and all that legal stuff. But that's her job, is to help him work through those questions.
And this whole case hinges on, we're saying, a violation of the Civil Rights Act. Explain how this hinges on that. What makes it a civil rights case, and what was the court trying to ferret out to make sure that it really does fit on that?
Right. So the Civil Rights Act says that a business or the government that has a certain number of employees can't discriminate on several different protected characteristics, such as race, sex, national origin, and religion.
Right.
And so what that means is if you're employed by a city government, like in this case, or maybe by a larger company, they can't use religion as a basis to punish you in your job or to ultimately fire you from your job. And that's what happened to Chief Hiddle here, is he was fired for attending a leadership conference that happened to be held at a church.
Let's give me just the 3-sentence version of his case for those that haven't heard it before. Explain it just as simply as you can.
Sure. So Ron Hiddle was the fire chief of the city of Stockton in California. And one of his city managers came to him and said, hey, you really should get some leadership training. And so he learned about this global leadership summit that's put on by Willow Creek Church up in Chicago. They were having a session of that at a church in the Bay Area. He grabbed a couple of his managers from the fire department and said, hey, let's go over there. They paid their own way and went, and they heard from world-class, leaders in business like Jack Welch of GE and Sheryl Sandberg of Facebook. And I mean, these are people that you would hear at any premier leadership event.
Yeah.
It just happened that it was put on by Willow Creek Church, and it took place at a church in the Bay Area. And so,
go ahead.
And so that was really the reason that was the sole reason the city got so upset at Chief Hiddle, was because he attended, quote, a religious event, which it wasn't a religious event, it was a leadership seminar
that happened to be at a church.
It happened to be at a church, and so they fired him for that.
Yeah, there seemed to be some fussing, and not an attorney, so I'm trying to understand what I saw, over who paid for it. I mean, I heard the one judge say, well, the city paid for it, right? They paid for their transportation and everything. But then our argument is, no, they paid for it themselves. Why the discrepancy there?
Yeah, I mean, I guess there's some discrepancy there. The facts in the case, though, are that Chief Hiddle and his co-managers from the department, they paid for it themselves.
Yeah.
And, they did go during city time, I guess. But at the same time, he was encouraged by the city to go get this leadership training. And they weren't specific about what it needed to be. And he thought, well, hey, I can go hear from these world-renowned corporate leaders. Yeah. What an opportunity. Who wouldn't want to take that up? And
I've been to a Willow Creek session, one of their leadership seminars, and I was frankly, because I didn't know a lot about it going in, was surprised and impressed by the breadth of the talent that was on the stage, one after another. People I wouldn't have expected to see, even that aren't, if I can say it this way, not churchy people. I'm not saying whether they're Christian or not, I don't know, but that's not what they're known for. Right. It's not like they're stars in the Christian realm and had just written a book. These are people who have broad audiences that they get to speak to, or big companies that they get to lead. In employment cases that have a civil rights violation in them, the other attorney, the one for the opposite side, will often start saying, well, they were also fired for this and for this and for this and for this. And we heard that. That's exactly what the attorney did. Unpack that for us.
Yeah, I mean, that's what you want to do. If you're defending the employer's decision to fire somebody, you're going to come up with all these other reasons why they should have been fired. The problem here is that the city of Stockton put it in writing. Not only that, they had an investigator come in. The investigator concluded that the religious nature of the leadership conference, the fact that it was held at a church, was the reason that Chief Hiddle should be punished. And when the city ultimately made its decision to fire him, they did it because of the religious nature of the conference. Now, they can say there's all these other reasons in addition to that, but they still made a decision based on religion, which the law doesn't allow.
And not to get too deep into this, but the attorney for the city, that's his job. He's just making the best case he can. So he's going to say, well, he did this, and he did this, and he did this, and he did this. But really, when you look at the record, it just doesn't matter, right?
That's right. Yeah, it just doesn't matter under the law. They used religion as one reason to terminate him, and that's sufficient for his case, for him to prevail at the appellate court there.
I got a text after it was over from someone who was watching the rebuttal. That's when Elizabeth Butler, for our side, had a few minutes at the very end to make her final appeal. And the one judge kept asking question after question. It seemed like she couldn't finish a thought. And this the person who texted me was not happy about that. As someone who watches these all the time, is that normal? Is that how it goes?
Yeah, and I've done lots of arguments like this, and it's not unusual for one judge to have a lot of questions. This one obviously did, and that's perfectly fine. I mean, like I said at the beginning, that's one of the reasons you have an oral argument in a case like this, is so that the judges can get their questions answered. And you're actually thankful that they're asking them, because that you're helping them work through some of those more challenging points in the case and hopefully understand that your client should win based on what the record and the law says.
And I noticed she very graciously said, I see my time is up. Am I allowed to answer the question? And Judge Gould said, absolutely, you may. Go ahead.
That's right. And that's just proper decorum. When you're at the appellate court, it's the court and the presiding judge, Judge Gould, he decides, whether you can have extra time to answer a question or not. Sometimes they're more strict. Sometimes they want those answers. And so I'm thankful that he gave her a little bit more time to answer the question.
Those of us who don't follow these things real closely all wonder what happens next. So what do the three judges do, and when might we expect an outcome?
Yeah, so what they do after argument typically is they'll go back, they'll meet, and they'll vote on which way they think the case should go.
Yeah.
And then they'll start writing an opinion if it's unanimous. If there's disagreement, if it's 2-1, then there will be two opinions being written, usually a majority and a dissent. And that'll take some time. It'll take many months. It could come out in 4 months. It could come out in 12 to 24 months. This is the Ninth Circuit. They're extremely busy. They have a huge geographic reach in the western part of the country, and they do have a lot of judges, but they have a lot more cases, and so it's a very busy court, and so it could take some time for us to actually get a decision. But like I said, I'm hopeful that we'll get a good decision for Chief Hiddle in the end.
So basically now we wait.
That's right.
And wait some more.
That's right.
Anything else you'd like to share before I let you go?
I just want to say thank you to our volunteer attorneys at Baker Botts, Elizabeth and Aaron. I also want to say thank you to one of our co-counsel, Alan Reinach, who he was actually one of the trial court attorneys for Chief Hiddle, and who we've had the pleasure of working with on several cases now. Alan's with the Church State Council, which is a branch of the Seventh-day Adventist Church, and he is an expert in employment law. And so, Chief Hiddle couldn't have had a better group of attorneys in the trial court. Alan was part of that team, and we're privileged to be still working with him on the appeal now. And
Alan is also with us on the Groff case, which we've got at the Supreme Court in just a few weeks.
That's right. Yeah, Alan, like I said, he is a employment law expert. He's been doing this for many years. He just has a tremendous ministry through the Church State Council. Him and Randy Wanger, who's at the Independence Law Center in Pennsylvania, they worked on Gerald Groff's case in the trial court and worked with us at the appellate court, and now we're going to stand next to him in the U.S. Supreme Court in about a month or so, a little less than that.
Yeah. So, April 18th, I think, is the day. We will be live on the steps of the U.S. Supreme Court, and much as we did on Monday, we will share that argument as it happens. The Supreme Court doesn't let you watch, but you can listen to the audio that they stream out live, so we'll be sharing that with you here in just a few weeks. If you want to see, we had an interview with Alan Reinach and Randy Wanger just a week ago on FirstLibertyLive.com, so if you go to FirstLibertyLive.com, you can find that interview and hear what they have to say. Looking forward to the Gerald Groff case. David, thank you so much. I appreciate the work you do. You guys do awesome work here at First Liberty.
Thank you.
Very proud of you. We invite you to subscribe at firstliberty.live. Let me say it right, at firstlibertylive.com, so that you can keep up with these conversations and all that's going on. As we mentioned, we're going to be at the Supreme Court in just a few weeks. You won't want to miss that. So firstlibertylive.com, just look for the subscribe button up there on the page, and it will notify you by email when we have new episodes that are coming out. First Liberty is fighting for what matters most.